A plain language walkthrough of California Form FL-190, the Notice of Entry of Judgment the court clerk mails to both parties once a divorce judgment is entered, including why the entry date matters and common mistakes to avoid. What is Form FL-190? Form FL-190, Notice of Entry of Judgment, is the California Judicial Council form the Superior Court clerk uses to give both parties official notice that a judgment has been entered in their family law case. It is filed alongside the judgment, FL-180, so it is ready for the clerk to complete once the judge signs off. Once the judgment is signed and entered, the clerk fills in the entry date on FL-190 and mails a filed copy to each party. This is how both the petitioner and the respondent receive formal, dated confirmation that the case has reached judgment without either side having to ask the court for an update. How FL-190 relates to the judgment, FL-180. It helps to think of these as two separate documents with two separate jobs, FL-180, Judgment, and FL-190, Notice of Entry of Judgment. FL-190 does not add new orders or change anything the judgment says. It exists purely to document, in writing, the date of entry and to give both parties a mailed record of it. For the full walkthrough of what goes into the judgment itself, see how to fill out Form FL-180. Section-by-section walkthrough of FL-190. FL-190 is short compared to most family law forms. Here is what appears on it. Case information. At the top of the form, you'll enter the county of filing, the names of the petitioner and respondent, and the case number. This should match exactly what appears on your judgment, FL-180, and the rest of your case file. Party names and mailing addresses. FL-190 lists the mailing address for each party, since this is what the clerk uses to send the notice. Both the petitioner's and the respondent's current addresses go here, or the address of an attorney of record if either party is represented. Double-check that both addresses are current before this form is submitted with your judgment. An outdated address means the clerk's mailed notice may not reach the intended party, even though the judgment itself has still been entered. Entry date. Completed by the clerk. This is the section the clerk fills in once the judgment is entered into the court record. It states the date of entry, which becomes the operative date for everything that follows, including when the marital status ends in a dissolution case. Certificate of mailing. The clerk completes this section to certify that a filed copy of the judgment and the notice of entry of judgment was mailed to each party. This creates an official record that both sides were notified, separate from anything either party has to do themselves. Why the entry date matters. The date the clerk enters on FL-190 is not a formality. It is the legal marker for when your case is truly finished. In a dissolution case, this entry date is when the marital status officially ends and each party becomes legally single again. That date cannot be earlier than the end of California's mandatory 6-month waiting period, which begins running from the date the respondent was served, not the date the petition was filed. A few things commonly hinge on the exact entry date. When you are legally free to remarry, when property division and support orders formally take effect, deadlines for certain post-judgment motions or appeals, which are often measured from the entry date. Getting certified copies after entry. Once you have received your FL-190 and know your judgment has been entered, you will often need a certified copy of the actual judgment, FL-180, afterward, not just the notice. Certified copies commonly come up for a legal name change on a driver's license, passport, or Social Security records, updating beneficiary or benefits information tied to marital status, providing proof of marital status if you plan to remarry. You can request certified copies from the Superior Court clerk in the county where your case was filed, generally for a small per-copy fee. Confirm the current fee and process with your county's self-help center, since procedures can vary slightly by county. Common mistakes to avoid. Listing an outdated mailing address for either party, which delays actual notice even after the judgment is entered. Confusing FL-190 with the judgment itself, FL-180, and assuming the notice contains the court's actual orders. Losing track of the entry date once FL-190 arrives, then struggling later to confirm exactly when the case became final. assuming the marital status ends on the date the judgment was signed rather than the date it was entered. Not requesting certified copies of the judgment until they're urgently needed for something like a name change. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your FL-190 for you. Virdix is a document preparation service, not a law firm. So this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.